As we have seen across the world time and time again, what comes before gun confiscation? Gun registration.
Right. The Sixth Circuit, I think, ruled yesterday. A panel of the Sixth Circuit. There's a prior en banc.
I certainly said that I was in that political campaign, which is far different from where I am now.
Dettelbach is the director of ATF. Do you agree with President Biden?
Into criminal just for owning a piece of plastic is really where you should put so much emphasis?
That you said that all assault weapons should be banned. Is that a fair statement?
Supreme Court's key case. The Supreme Court's upcoming decision on the ATF's classification of bump stocks is like the ultimate showdown in the Wild West of gun rights. The ATF decided these bump stocks, these little attachments that amp up a rifle's firing speed, qualify as mash guns under the law. But hold your horses, it's not that simple. This case is a total game changer in the debate over who gets to call the shots, literally, when it comes to defining what's covered under the Second Amendment.
As we have seen across the world time and time again, what comes before gun confiscation? Gun registration.
To try and determine, and it's hard work to determine what things are and are not covered, how you define those terms.
Whether intentional or unintentional, of Biden administration officials and anti-gun advocates and even the president himself.
If the court backs the ATF, it means they're giving the agency a green light to expand their reach over gun regulations. That's huge. Suddenly, a simple add-on to a rifle falls under the same strict rules as a full-blown mash gun. But if the court rules against the ATF, it's like saying, "Whoa there, partner, you're stretching those gun laws a tad too far." Why does this matter to all of us? Well, the Second Amendment's kind of like the Constitution's rock star. It's about your right to bear arms, but also about the government not messing too much with that right. If the ATF can rope in bump stocks under the mash gun label without proper backing, it sets a precedent for them to wrangle in other firearm accessories down the line. Suddenly, everything from pistol grips to scopes might fall under stricter regulations.
Right. The Sixth Circuit, I think, ruled yesterday. A panel of the Sixth Circuit. There's a prior en banc.
Stabilizer brace owners who do not wish to register their firearms, the ATF provides four alternatives.
See, it's not just about bump stocks. It's about the broader power play. This ruling could redefine the whole landscape of gun regulations. And let's be real, folks on both sides of the gun debate are waiting with bated breath to see where this showdown leads us. Imagine the fallout. If the court sides with the ATF, gun owners might feel like their freedoms got lassoed tighter. On the flip side, a ruling against the ATF could mean a win for gun enthusiasts, signaling that the government can't just snap its fingers and make every accessory fall under stricter rules. So when the gavel drops on this case, it's not just about a tiny piece of hardware. It's about the big old question of who gets to decide what's covered under your right to bear arms. The Second Amendment might not be up for grabs, but its boundaries sure are, and this case is drawing a line in the sand. Fifth Circuit's decision and implications. All right, buckle up for a legal roller coaster. The Fifth Circuit Court was like a sheriff in a shootout when it took on the ATF's reclassification of bump stocks as mash guns. The ATF tries to rope in these bump stocks as mash guns, but the Fifth Circuit's not having it. They took a long, hard look at the ATF's move and said, "Nuh-uh, that ain't flying." In their ruling, they basically said the ATF was overstepping its boundaries. It's like they slammed the brakes on the ATF's wagon and said, "Hold your horses, you can't just slap the mash gun label on everything you fancy." Now, why does this matter so much? Well, it's a bit like the Wild West out there with gun regulations. The ATF's trying to lasso in more stuff under strict rules, but the Fifth Circuit said not so fast. This ruling wasn't just about bump stocks. It was about telling the ATF, you can't wrangle in items under stricter regulations without a darn good reason.
I certainly said that I was in that political campaign, which is far different from where I am now.
And what I'm saying is,
Just answer this question. As you interpret the statute, I assume you're familiar with the statute.
Can I ask for 5 minutes?
Thank you, Mr. Chairman. Director Dettelbach, what is the core mission of your agency?
This decision wasn't just a slap on the wrist, it was a warning shot. It challenged the ATF's authority to redefine what's covered under gun laws, and that's a big deal. Imagine if the ATF could just wave their regulatory wand and suddenly every little accessory was under stricter rules. It'd be like turning a peaceful town into a gun control showdown. So this ruling had gun enthusiasts doing a little victory dance. It was like a sign saying, "Hey ATF, you can't just cowboy your way through gun regulations without proper legal backing." It also signaled that courts might be keeping a closer eye on the ATF's moves, making sure they stick to their legal holster. Bottom line, the Fifth Circuit's decision was a game changer. It wasn't just about bump stocks. It was a message to the ATF that they can't play fast and loose with the law. It put a big old question mark on the ATF's attempts to expand their regulatory reach without proper legal ammo. And trust me, in the world of gun regulations, that's a showdown worth watching. Chevron defense versus rule of lenity. All right, partner, let's mosey on over to the legal showdown between the Chevron defense and the rule of lenity. This ain't just your regular courtroom debate. It's a clash of legal doctrines that could tip the scales in a mighty big way. The Chevron defense is like giving the ATF a nod and saying, "Hey, y'all know best." It's all about deferring to the agency's interpretation of the law. The ATF says bump stocks are mash guns, and Chevron defense says, well, if the ATF thinks so, then it must be so.
The ATF finalized its unconstitutional rule pertaining to firearms with stabilizing braces.
Well, I've got here the actual original brace that this letter was responsive to.
I think what I said was that there should be an assault weapons ban.
It's like giving the agency the benefit of the doubt and letting them call the shots. Now, on the other side of the dusty street, we've got the rule of lenity, which is a whole different breed. It's like the friendlier, citizen-centric approach. This rule says, hold up, let's give folks the benefit of the doubt. It leans towards interpreting laws in a way that's more favorable to the folks on the ground, not the big agency in the saddle. Now, here's where it gets interesting. This debate ain't just about legal jargon. It's about who holds the reins in shaping gun regulations. In our case, it's like asking, should we let the ATF ride on through with their interpretation, or should we give gun owners a fair shake? The outcome of this debate ain't just about bump stocks. It's about setting a precedent for how future gun-related matters get handled. If the court tips its hat to the Chevron defense, it's like saying agencies can call the shots without much scrutiny. But if they tip the scales toward the rule of lenity, it's a signal that courts are going to keep a closer eye on how these laws get wrangled.
You were asked a question by a Democrat earlier about statistics on the defensive use of firearms.
I don't want to repeat the answers I've given because I know you have limited time, but no, I don't believe
big
that.
priority for your agents?
And I don't believe...
Dettelbach, as the director of ATF, you do agree with President Biden that
Think of it as the difference between letting the sheriff run the town without question or making sure the townsfolk have a say in how things go down. This debate's got broader implications, partner. It's about who gets the say in interpreting laws, big agencies or the folks those laws affect. So when the court weighs these legal doctrines, it's not just about bump stocks, it's about the future of how gun laws get read and who gets to shape them. And that, my friend, is a mighty big showdown in the realm of legal wrangling. ATF's argument. The ATF's got their 6 shooters loaded with a unique argument in this here bump stock saga. They're not just talking mechanics, they're all about the shooter's dance with the trigger. It's like they're saying, forget what the gizmo does, let's talk about how the shooter twirls it. Their arguments, like this: bump stocks let a shooter fire off multiple rounds with a single squeeze or motion. It's not about the technical ins and outs of the device, it's about how it changes the shooter's interaction with the gun. They're saying, look, it's not about the gun itself being auto, it's about how this contraption changes the shooting process. When they saddle up to the Supreme Court, they're spinning a tale about how bump stocks let folks fire off rounds in a way that feels like a quick-draw showdown. Their argument saying, this thing makes shooting faster and easier, so it's like turning a regular shooter into a gunslinger. But here's the twist in their yarn.
And I think the president has given numerous different times he's talked about this provision.
Into criminal just for owning a piece of plastic is really where you should put so much emphasis.
Informed law-abiding gun owners possessing pistols with these braces attached.
They're aiming to steer the court away from the technicalities of the law and focusing on the shooter's moves instead. It's like they're saying, look past the legal jargon and see the shooting dance this thing enables. They're making a stand that the law should focus on how a shooter interacts with the firearm, not just the gizmos and gadgets attached to it. It's their way of saying, hey, this ain't about the mechanics, it's about the action it allows. Their arguments got folks thinking. Does the law really care about how a shooter does their dance with the trigger, or is it more about what's bolted onto the gun? It's a real head-scratcher for the court, trying to figure out if the law's more concerned with the shooter's finger or the gear they're using. So when the ATF's making their case, it's not just about bump stocks, it's about shaping how the law sees firearms and their accessories. It's about whether the shooter's moves take precedence over the nuts and bolts of the gun. And let me tell you, partner, that's a twist in the tale of gun laws that's got everyone's attention. Clarity of mash gun definition. The ATF's been doing a bit of a two-step shuffle when it comes to bump stocks. They used to reckon these gizmos weren't mash guns, but then suddenly they changed their tune. Now they're singing a different song, calling bump stocks the real deal. Their history's a bit like a tumbleweed in the wind. See, from the early 2000s to around 2018, the ATF was on the record saying bump stocks weren't these here mash guns. They were clear as crystal, saying these doodads didn't turn rifles into full-blown auto weapons. It was like they were saying, nah, bump stocks ain't in the same corral as mash guns. But then, out of the blue, they switched their spurs. Suddenly they're saying, yep, these bump stocks are mash guns after all. It's like they did a quick draw and changed their stance faster than a gunslinger in a showdown. Now this flip-flop dance they're doing ain't just stirring dust, it's clouding up the definition of a mash gun like a sandstorm. If the ATF can't make up their minds about bump stocks, it's got folks scratching their heads about what exactly makes a mash gun.
And Mr. Bosco, I think before this committee, said that people were using stabilizing braces in ways that he hadn't anticipated.
Are you aware that CDC used to track that and that they've removed it from their website?
That you said that all assault weapons should be banned. Is that a fair statement?
It's like the definitions become as murky as a muddy river. This changing stance isn't just about bump stocks. It's throwing a wrench in the gears of how we understand the law. If the ATF can waltz around their own previous rulings, it makes you wonder how clear the law really is. It's like asking, can we trust the ATF to stick to their guns on what's what? See, it's not just about bump stocks being called mash guns. It's about the consistency of the folks in charge of interpreting these laws. If they're doing the hokey-pokey with their opinions, it makes it mighty hard for regular folks to know what's what when it comes to gun laws. So when the ATF's doing their fancy footwork with their stance on bump stocks, it's not just a shuffle in the courtroom, it's clouding up the whole darn definition of a mash gun. And in a land where clarity counts, this back and forth has folks squinting harder than a cowboy in a sandstorm, trying to make sense of it all. Second Amendment landscape at stake. This year's Supreme Court ruling ain't just about bump stocks. It's like a wildfire that could change the whole landscape of Second Amendment rights. The court's decision ain't just a ripple in the pond, it's a mighty wave that could shake up how we see our gun freedoms. If the court tips its hat to the ATF and says, yep, bump stocks are mash guns, it's like giving the government a bigger rope to wrangle in gun regulations. Suddenly it's not just about bump stocks, it's about the ATF having more say over what accessories and doodads get thrown under stricter rules. It's like they're widening the corral of what falls under their control.
Weapons and high-capacity magazines in 3 communities in 3 different states in our nation. Enough.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
For God's sake, America already has more guns than people. How many guns do we need until everybody is safe?
But hold your horses. If the court says, nah, ATF, you've stretched this law too far, it's like giving a nod to gun owners and saying, your rights won't be lassoed so easily. It's a message that the government can't just hoot and holler and make every gun-related item fall under stricter rules without clear backing in the law. Now, here's the thing. This ruling's got a bigger shadow than just bump stocks. It's like a lantern in the dark, shedding light on how future gun-related matters get handled. If the court swings one way or the other, it's setting a precedent for how the Second Amendment's boundaries get drawn. Imagine a town where the government can decide what kind of sights or grips you can slap on your firearm. That's the kind of territory we're entering if the court leans toward giving agencies more regulatory power. But if they stick to a narrower interpretation, it's like telling the government, you can't ride roughshod over folks' gun rights. So when the dust settles on this ruling, it's not just about bump stocks, it's about the future of our gun freedoms. It's about whether the government gets a longer leash to dictate what gun owners can and can't do with their firearms and accessories. And let me tell you, that's a frontier where every decision counts. Beyond bump stock regulation. Absolutely, let's dive into the ripple effect this ruling might stir up beyond just bump stocks. Picture this ruling as a stone dropped in a pond. The waves might reach far and wide in the realm of firearms and regulations. Now, if the court gives the nod to the ATF's classification of bump stocks as mash guns, it's like opening the gates to a whole corral of stricter rules. Suddenly, the ATF might feel emboldened to lasso in more accessories and gear under the same umbrella. Pistol braces, those handy devices used for stability, they might be next on the list. The ATF might reckon they're too close to stocks and slap them with tighter restrictions. And suppressors, those nifty gadgets that muffle gunshots, they've always been a hot topic. A ruling favoring the ATF could mean the agency's got their sights set on cranking up the regulations there too. Private party transactions, where folks sell firearms without a background check, that might get the government's lasso swinging in to bring them under stricter oversight.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
There should be an assault weapons ban. I think it would have been up to the Ohio legislature.
It wasn't the fully automatic machine gun that was banned in 1986. It wasn't the bump stock.
But hold your horses. If the court bucks against the ATF's move on bump stocks, it's like slamming the brakes on this expanding regulatory rodeo. It might signal to the ATF that they can't just wrangle in every accessory without a clear legal basis. This ruling's got the potential to influence how the ATF approaches a whole range of firearm-related items. It's like a signpost for their future moves. If they get the green light on bump stocks, it might embolden them to cast a wider net. But if they're told to rein it in, it's a message that they've stretched the law too far. So when the gavel falls on this case, it's not just about bump stocks, it's about the domino effect on various firearm-related items. It's about whether the government's reins on gun regulations get pulled tighter or if they're reminded to keep their lasso in check. And that could shape the future of how we handle firearms and their accessories. Broader implications. This Supreme Court showdown over bump stocks ain't just a one-time deal. It's a frontier that could redefine how the ATF wields its authority over firearms. If the court tips its hat to the ATF's classification of bump stocks as mash guns, it's like handing them a bigger badge with more regulatory power. Think about it. The ATF might see this as a green light to corral in more firearm-related items. Suddenly, they might reckon they've got a free rein to rein in other accessories and gadgets under stricter rules. It's like saying, y'all can regulate what you think fits the bill. But hold your horses. If the court swings the other way and says, hey ATF, you've overstepped your boundaries, it's like a warning shot. It might rein in the agency, telling them they can't just mosey on in and call the shots without a clear basis in the law. This ruling's got implications beyond bump stocks. It's about the ATF's authority over the entire corral of firearms and accessories.
Under the new rule, firearm owners will be required to obtain special registration, surrender or destroy their brace.
Ban assault weapons. Ban them again. Do it now. Enough. Do something.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
If they're given more leeway, it might embolden them to rope in more items under stricter regulations. But if they're reined in, it's a message to keep their spurs in check and stick to the letter of the law. Now here's where the dust settles. This ruling could set the tone for how the ATF interprets and enforces firearm-related laws. If they're given a broader scope, they might start rounding up more gear and items under stricter rules. But if they're reminded to stay within their legal boundaries, it's like saying, y'all gotta follow the law as it's written. So when the court's ruling echoes through the plains, it's not just about bump stocks. It's about the ATF's reign over the entire realm of firearms. It's about whether they're handed a bigger lasso to rein in more items, or if they're reminded to stick to their legal holster. And that could shape the whole landscape of firearm regulations in the days to come. Upcoming Supreme Court rulings. The Supreme Court's about to enter a showdown on Second Amendment rights, and it ain't just one case riding into town, it's a posse of cases that could redefine the whole gun rights landscape. This ain't just about one ruling, it's a whole showdown shaping up on how we see and interpret the Second Amendment. First up in this legal roundup is the case that got folks talking. The showdown over bump stocks. This case ain't just about those attachments that make rifles fire faster. It's about the ATF's authority to wrangle in firearm-related items under tighter regulations. But hold on to your hat, 'cause it ain't riding solo. There's a whole gang of cases lining up behind it. One's the LBE case, a sneakier one about the Chevron defense, where the ATF's regulatory reach could get a nod or a yank. Then there's the Rahimi case, a showdown over a two-way prohibited person case that could shape how gun rights are viewed for folks with past convictions. Now, why do these cases matter beyond their individual gun smoke? Well, these cases are like puzzle pieces in the broader canvas of Second Amendment interpretation. They're not just about the specifics of bump stocks or a person's criminal past. They're about the court's brushstrokes on how we see and understand the Second Amendment.
That men and women in this country have the right to defend their own lives.
A critical and urgent issue, gun violence in America. We're here because gun violence is destroying communities.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
Imagine these cases as threads in a tapestry, each adding its own color to the bigger picture. If the court rules in favor of the ATF in the bump stock case, it could set the tone for how agencies interpret gun laws, not just for bump stocks, but for a whole range of firearm-related items. And that could ripple through to the other cases, influencing how they're viewed and decided. But flip the coin, and if the court says, "Whoa, ATF, you're stretching it," it's like a signpost for more limited agency authority. It's a signal that agencies can't just cast a wide net over gun regulations without clear legal backing. And that's not just for bump stocks, it's for all firearm-related matters in the legal crosshairs. These cases aren't just individual squabbles in the legal saloon, they're the foundation for how the Second Amendment gets shaped and understood. Each ruling's like a pebble dropped in the pond, sending ripples that touch everything from agency authority to individual rights. So when the Supreme Court gears up to decide these cases, it's not just about settling disputes. It's about sketching the landscape of Second Amendment interpretation. It's about painting the canvas of gun rights, deciding who holds the brush when it comes to defining and shaping our understanding of those cherished rights. And that makes these cases more than just legal showdowns. They're defining moments in the story of gun rights in America. Significance of the court's decision in 2024. The Supreme Court's decision on Second Amendment-related cases in 2024 could be like a stone tossed into a pond, creating ripples that reach far and wide across the legal and societal landscape. It's not just about a single judgment, it's about the echoes that decision sends through the corridors of power and everyday life. First off, let's talk impact. This ruling ain't just a legal joust, it's a signpost for the future of gun rights. If the court leans towards broadening agency authority, it could set the stage for more regulatory control over firearms and related items. Suddenly, the government might feel emboldened to cast a wider net over what's regulated, impacting everything from accessories to private transaction. But flip the coin, and if the court reins in agency authority, it's like a message to keep the government's regulatory ropes tighter. It's a reminder that gun rights aren't to be corralled without clear legal backing. This could influence everything from how agencies interpret laws to the extent of their reach in shaping regulations.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
Americans have the fundamental right to keep and bear arms that shall not be infringed.
Seizure of weapons from the homes of law-abiding American citizens.
And let's talk society. This ain't just about legal jargon. It's about how these rulings affect folks like you and me. A decision favoring broader regulatory power might change how gun owners interact with their firearms, potentially impacting access and ownership. It could also affect how agencies enforce these laws, influencing law-abiding citizens and businesses. Now, why does it matter to stay informed? Well, these rulings ain't just headlines for the legal folks. They're about our rights, our freedoms. Staying in the know helps us understand how these decisions shape our lives. It's about knowing the rules of the game, understanding how our rights might shift, and being prepared to engage in conversations about gun rights in our communities. When the gavel falls on these rulings, it's not just about the legal mumbo-jumbo, it's about the future of our gun rights, our responsibilities, and the broader impact on our society. So staying informed isn't just a suggestion, it's like holding a compass in this ever-changing terrain of rights and regulations. It helps us navigate through the implications of these rulings and understand how they affect our everyday lives. And that, my friend, makes these decisions more than just legal dictums. They're keystones in the ongoing story of gun rights and responsibilities in our nation. That's all for this video, folks. We'll see you next time.